All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Apologies for the technical difficulties and the slight delay. Today we have our second briefing of the session. It is a two-part briefing. The first part will be on the Bruin case, the recent Supreme Court case, and we'll discuss the impacts and implications on Maryland law from the Bruin case. So we'll start off with a brief primer of the case history and the case law with from our counsel, Jamie Lancaster. Then we'll move on to our Maryland State Police, and then we'll have Dr. Daniel Webster from Johns Hopkins University Center on Gun Violence Solutions present. Then we'll have Mark Pennick from Maryland Shall Issue, and then we'll end our briefing with Sam Levy from Everytown. We'll then break and start the second portion of our briefing, which will address trends and efforts to combat gun violence in Baltimore City. And we'll have our state's attorney from Baltimore City, Ivan Bates. Commissioner Harrison will be here, and then Shantae Jackson from the Mayor's Office of Neighborhood Safety and Engagement will also present, and then we'll wrap up and conclude with Dr. Webster again from Johns Hopkins University. So with that, we'll start off with our first portion of the briefing. And Jamie, are you going to present from here, or are you going to go up to the dais?
Sure, I'll go up to the dais. Good afternoon, members of the committee, Mr. Chair, Mr. Vice Chair. For the record, my name is Jamie Lancaster. I'm with the Department of Legislative Services. As you know, but those at home may not, DLS is the nonpartisan department that provides support to members of the General Assembly. And in that role, I am assigned as committee counsel to this committee. I'm here today at the request of Chairman Smith to start off today's briefing with just a short overview of the decision in New York State Rifle and Pistol Association versus Bruin. In that case, the U.S. Supreme Court issued a ruling this summer that had impacts nationally and here in Maryland. In general, the Supreme Court in Bruin overturned a longstanding New York law requiring that applicants for a concealed carry handgun license demonstrate proper cause or a special need for self-protection in order to obtain a handgun license. This was, of course, on the grounds that it violated the Second and 14th Amendments of the U.S. Constitution. The case is notable for several reasons. First, the New York law that was overturned was similar to the laws in 6 other states, including Maryland. Maryland statute requires that applicants for a permit to wear and carry a handgun demonstrate a good and substantial reason to wear, carry, or transport a handgun. The majority in Bruin held that carrying handguns in public for the purpose of self-defense is within the plain text of the Second Amendment. The court rejected a balancing test that had long been used for assessing constitutionality of firearm regulations. That test had previously would weigh the government's interest supported by the regulation against the burden on an individual's rights under the Second Amendment. Instead, the court held that assuming the regulation applies to conduct that falls within the Second Amendment's plain text, the government now has the burden to justify a firearm regulation by showing that the regulation is consistent with the nation's historical tradition of firearm regulation. In Maryland, following the Bruin decision, on July 5th, Governor Hogan ordered the Department of State Police to no longer enforce the good and substantial reason in issuing wear carry permits. A day later, on July 6th, the Office of the Attorney General sent a letter to the Maryland State Police advising that in light of the Bruin decision, Maryland's good and substantial reason requirement was unconstitutional. And then on July 27th of 2022, the Court of Special Appeals ruled in the matter of William Rounds that the good and substantial requirement in Maryland was unconstitutional in light of the court's Bruin decision. So that's just a very brief overview of the Bruin case and the impacts in Maryland. So I'll turn that over to you, Mr. Chairman.
Yeah, thank you very much, Mr. Lancaster, for the history. So we're going to now switch over to Maryland State Police. And just before we get started, for the committee members, this isn't a bill hearing. This is just an informational session. So the lines of inquiry will just be kind of just the facts and how the Bruin decision has impacted the licensing process, the number of applications, where they're coming from, and what they're seeing at the ground level. So if you all would like to come up to the table here, it's a pleasure to bring up Captain Andrew Rosignol, Lieutenant Shackelford, and Corporal Taylor from the Licensing Division. So the floor is yours.
Good afternoon. Thank you, Mr. Chair, committee members. Appreciate having us here today. Again, like the Chairman said, my name is Andrew Rosignol, Commander of Licensing. We have our Assistant Division Commander here, Greg Shackelford, and our Handgun Permit Section Supervisor, Corporal Josh Taylor. Just to give a quick overview of what License Division is responsible for: a regulatory body administrating the laws and conducting investigations regarding some of the following applications: handgun qualification license, the handgun instructors, sale and transfer of regular firearms, machine guns, things of that nature, firearms registration dealers, commissioning of special police, railroad police officers, private detectives, private detective agencies, security guard agencies, alarm companies, alarm technicians, registration of canine dogs, wiretapping devices, things of that nature, LEOSA, and handgun permits, why we're specifically here. At this time, after introductions, I'm going to defer the question answer and some statistical data supporting this inquiry today to Corporal Josh Taylor, who is our handgun permit supervisor, one of the lead supervisors responsible for administering the handgun permit.
Good morning, Mr. Chairman, members of the committee. My name is Corporal Joshua Taylor, Sr. I am a member of the Maryland State Police Handgun Permit Unit, one of the two sworn section supervisors. Part of my duties entail the operational facilitation of the unit, as well as preparing all of the disapproval appeals to the Office of Administrative Hearings. It was no surprise that the landmark decision on June 23rd of 2022 in the Bruin decision greatly impacted the handgun permit unit. To kind of put this in perspective, in the years 2018, 2019, 2020, and 2021, we approved on average between 13,000 and 14,000 applications per year. Post-Bruin decision, June 23rd of 2022 to December 31st of 2022, we approved over 80,000 applications. So essentially, in the months since the decision, we've, in essence, conducted about 1 year's worth of work each month. That has been a major impact on the division, the unit, and fortunately we have good personnel that have kind of put their nose to the grindstone to make sure that citizens both here in the state of Maryland as well as outside of the state who are submitting applications to the state police, those applications are processed in a expeditious manner. Mr. Chairman, I'll open this up for any questions.
Thank you very much. I'll defer to the committee first for questions, and then I've got a couple. Yes, Senator West.
Thank you, Mr. Chair. I just have one question at this point. There's a distinction between concealed carry and open carry. How does the department deal with applications for carry permits where someone wants to conceal the weapon as opposed to carry it openly?
Use a handgun permit. There was no distinction, to my knowledge, in statute that clearly defines open carrying versus concealed carry. Statute does require an individual to possess a handgun permit to wear, carry, or transport a firearm.
Okay, so to the best of your knowledge, here in Maryland right now, there's no distinction between carrying a gun openly and carrying it in a concealed way insofar as permits are concerned.
To the best of my knowledge, sir, yes.
Thank you.
Yes, Senator.
Okay. Captain Taylor, how have you been handling this? I come from a budget committee, so I'm just curious, how were you able to expeditiously increase the amount of permits? Were you able to reassign officers to this task, and did that in any way take them from other vital services that they need to do for the state of Maryland?
That's a great question. It's a process that we are continually improving. We have had numerous folks from within the division reassigned temporarily to the unit. There have been individuals throughout the state police that have been reassigned on a temporary duty assignment to assist us with that influx.
Okay.
Fortunately, based on relationships we maintain with other state agencies, we've had personnel assigned to us. Currently, there are 2 personnel from Department of Public Safety and Correctional Services, a sworn corporal from Natural Resources Police, as well as other individuals who have volunteered to assist with the massive workload as a result of the decision. Unfortunately, those individuals have great work ethic. To their own detriment, they have sacrificed some time with their families to ensure that we're meeting our mandates.
Can I just this isn't why you came to testify or brief us, so if you don't know, I don't mean to put you on the spot, but are you aware if the state police is asking, because you're doing these temporary reassignments from other departments, I'm sure there's people who have essential work to do as well as your own, are you coming up with budget and personnel changes, and perhaps for you, sir, to try to meet this need, which I assume it will continue apace for a while?
Yeah, those are great questions, and Corporal Taylor here is to present information related to the raw numbers,
Yeah.
things like incoming, outgoing numbers. When it comes to personnel staffing, that's well underway. It has been a struggle with licensed division, not for just 2022, but
Okay.
previous years.
Okay.
So we're always looking at upgrading and doing additional staffing studies and requesting additional positions. What the corporal had mentioned earlier when it comes to other people helping out to meet the demand, historically, right now we have approximately 110 permanently assigned people assigned to licensing when it comes to full-time, temporary, part-time individuals. To meet the demand for 2022, we surged that personnel to almost double. Most of those individuals who are coming in are overtime, and then also the temporary duty assignment individuals, troopers, sworn, civilian, from allied state agencies, and then more importantly from our own component within the state police, just transferring and reallocating personnel to meet the demand.
And my last question, if you don't mind, Mr. Chairman, do you all, I don't know if you would know this, but based on your experience, do you think this increase from June to the end of the year of 80,000, right? Mm-hmm. Do you anticipate that will increase more as we go forward?
Well, I wish I could have a crystal ball to answer a lot of these questions. I don't. We are prepared to meet whatever demand comes in. We will always adjust resources, personnel to meet the demand. We clearly had an initial spike when the decision was made on June 23rd. We were exceeding some numbers of 1,200 applications per calendar day. We have now brought that number down, or the number has reduced drastically to about 300 to 400 per day. But you have to put in perspective, for 2021 and before, we were receiving about 225 per calendar week. So it's hard to judge what the future may hold. But at this point, we've been meeting the demand. In 2020, we also saw a spike in applications on the firearms registration side. So the playbook we ran last year, or in 2020, when it comes to bringing in extra resources, moving folks around to meet the demand, we essentially did that same thing last summer at warp speed.
Thank you, Mr. Chairman.
Thank you, Senator James. No, I'll just remind the committee that the budget is announced on Friday, so we'll see if there are pins that are reallocated. And obviously, TDYs are a good way to kind of stopgap, but they're not a long-term solution for folks. So we'll do Senator Sindor and then Senator Fulton.
Thank you. And good morning. Or good
afternoon.
afternoon. Yes. In your presentation, you had mentioned the increase in applications, and you had noted that they were in-state and out-of-state. And I'm curious, was the rise at the same rate for in-state and out-of-state applicants?
Specifically about in-state, I mean, there's never been an in-state requirement. You've never had to be a Maryland resident to apply.
Okay. So they're not. I mean, he made the distinction, so that's why I was I was
You could comment further if you had
wondering.
specifically
Right.
about that.
So I don't have specific numbers before me, but any individual who meets the requirements for the application can apply, whether they reside in the state of Maryland or in an adjoining state or elsewhere in the U.S. So as long as they meet those requirements of the live scan fingerprints, the training requirement, they can submit an application to the Maryland State Police for a handgun permit.
Was there a reason that you made that distinction when you were presenting?
Not necessarily. We have seen the influx increase, both in-state as well as individuals who reside outside the state of Maryland. I don't have those specific numbers before me to show any sort of rate of increase, but it has been substantial.
Just out of curiosity, for the folk who are living out of state, I'm assuming they're submitting these applications because would they do business in Maryland, or they come through Maryland, or what is it that, I mean, I'm guessing, is there a reason that's given as to why they would want to be licensed here in Maryland?
Not necessarily now. The rationale for the application is personal protection. So since the June 23rd, 2022 decision, that reasoning for the application and issuance of the permit is personal protection.
Yeah, just to elaborate a little bit on the out-of-state versus in-state, to be honest with you, that's not really a metric that we measure all that often. It really has minimal impact on our operations because of meeting the threshold within submitting the application, which is electronic now. It's been electronic for several years. But more importantly, the fingerprint and the training component, so that geographically could be limiting somebody from applying from West Coast here, meeting the live scan, the training, assuming they can do those things and they fly here or however they get here and do that, they would be eligible so long as they're not subject to a prohibiting factor.
Gotcha. Because the training would have to take place here in Maryland.
Not necessarily take place here in Maryland, but as long as they're certified instructor from the Maryland State Police to meet the training requirements, the live scan component is a big factor when it comes to that component of it. So they're not going to be able to traditionally roll fingerprints and mail them in. It would have to be transmitted electronically. So there's limited locations outside.
Thank you very much.
Thank you, Mr. Chairman. I guess to kind of piggyback on what Senator Sidnor was saying, I guess it's kind of like the people from out of the state would be those that prior to the Bruin decision were those that held the Utah permits, where you could carry, you know, anywhere across in 35 states or whatever it is at that point. Is that so? To kind of fill you in a little bit, so people want to be able to carry for protection across state lines. They don't want to get in trouble. Prior to Bruin, it was a heavier lift, per se, or let's just say that, for those outside the state of Maryland to travel through, even though they might have been a legal gun owner in Pennsylvania, Maryland, or a surrounding state, but if they drove through, they would have been in violation. So is that accurate? That's a similar vein that you would see from an out-of-state application?
I would say it's a fair assessment. I mean, again, speculation of what individuals and why they're applying. I mean, we're looking at if they meet the requirements. So, I mean, if they're going from Florida and they're driving to Maine and they happen to have a permit in every one of those states during that travel, of course,
Right.
then one would make an argument that would be appropriate.
Right. Thank you. And then the other question I had, you guys had such a significant spike, and this is in no way intended, this is not a trip you up question, this is not anything, but I just want to put this out there. Has the state police been able to still conduct the required NCIC checks of all the applicants prior to rendering any, before the 7-day period?
So this is a 90-day period for a handgun permit. The 7 days, the purchase of firearm. We've met all legal obligations.
I'm sorry.
Those. No, that's okay.
Yeah.
We've met all legal obligations by making sure that we have that decision rendered within the scope of the law.
Perfect. Thank you.
Thank you. No, I think it's a very good question because, as you mentioned, I mean, if you're now doing a year's worth of work traditionally now in a month, I mean, that's how much that you've gone from basically 13 to 14,000 to 80,000. So it's a significant increase. I know you've met the demand, you've performed the tasks, but I think again, me advocating for you all for more resources, I think that's something that, as the budget comes around, is something that I think we need to take a hard look at as a General Assembly, just to make sure that the resources are there. that those are being performed properly, and which they are, but as pace rises, it's a big deal. Can you get Senator Fulton's thing so I can amplify the mic? Thank you. I did have a question about the process, and I think it's important for the committee to understand what that process looks like. Some of us were here when the Handgun Permit Review Board was still a thing, and then we kind of changed that appeals process. Could you walk us through what that appeals process looks like, and on both sides of the house? So, you know, someone applies. This is all post-Bruin now. And have you seen a spike in denials or a change in denials? And just talk about some of the criterion that you sift through. So one part is, what's the process look like from appeal to you, internal appeal, OAG, circuit court, and on through? And then some of the criteria that you look at when you're going through the approval process, and how Bruin has changed that analysis.
Sure, and I'll start out by giving the quick, broad view, and then Corporal Taylor, who's the expert in that component, can give more detail. But to follow up on your question before, just to make it clear, with licensing all the different applications and components we have on the regulatory format, there's three main ones that come with strict legal requirements, and others are not mandated with that same turnaround as the HQL, which is 30 days, the handgun qualification license. The handgun permit is 90 days, and these are calendar days. And then that 77R traditional firearms transfer is 7 days. And we have not met any one of those obligations for 10 years, back from the surge in 2013. To go...
I just want to be clear that was a double negative. You said you have not met. You've met the requirements. All right, I just want to make sure everybody heard the double.
And we still conduct robust record checks and background checks on everything.
Yeah, right.
So I just want to make clear on those dates. They're very important. Obviously, we don't have no carve out. There's no exemption. We have to meet it, rain or shine, 7 days a week, holidays or anything. With the Bruin decision, when it comes to our appeals, nothing has changed prior to or after. Volume of work has slightly changed. When you apply, if you are denied for whatever factor, there is an appeal process. The first step is an informal review, which is done by a member of our command staff, looking at the nuances associated with it. In some cases, we're able to rectify that to the applicant's satisfaction or not, but not at the same time. They are entitled to the Office of Administrative Hearings. That conduit is through us. They request that, again, these things are done electronically through their application process. You can do it concurrently or you can do it separately. They would reach out to the OAH for a hearing. Those hearings are conducted by Corporal Taylor. If you want to take it from there, he exclusively does essentially almost 100% of our OAH hearings for handgun permits.
So in calendar year 2021, there were over 400 appeals to the Office of Administrative Hearings. Now, again, a majority of those dealt with the good and substantial reason. I expected those numbers to drop once the Bruin decision was announced. However, based on the influx in applications, we have seen similar numbers in handgun permit disapprovals and subsequent appeals to the Office of Administrative Hearings. Calendar year 2022, there were approximately 435 appeals to the Office of Administrative Hearings. A majority of those appeals are for either state or federal prohibitors. The same prohibitors that would prevent you from purchasing or possessing a firearm, as well as being issued a handgun qualification license. There are some nuances in Public Safety Article 5306. A conviction for possession of marijuana is prohibitive for the issuance of a handgun permit. However, that same individual with the same conviction could legally purchase or possess a firearm. There is another section of Public Safety Article 5306 that deals with a propensity for violence or instability. This, as I described to most judges, it's a gray area. We're looking at that complete criminal history check. We're looking at the number of incidents in which an individual has been arrested, the type of crimes they've been charged with, whether they're crimes of violence or not, as well as individuals who apply that are named as a respondent in a protective order. So those cases which fall into the minority of our applications, a very small fraction of those individuals or applications that we're reviewing quite in detail. However, that is one of the nuances of Public Safety Article 5306. That process for the appeal to the Office of Administrative Hearings is quite extensive. There's the preparation of the case, preparation of the evidence as well as discovery, and then preparing testimony and closing arguments before an administrative law judge. Prior to the Bruin decision, again, a majority of those cases dealt with the good and substantial reason, and there were some cases that were overturned as a result of that. To date, there have been, since the implementation of that process to the Office of Administrative Hearings, there have been over 1,100 appeals, and I believe, to my knowledge, currently there's been 26 cases that have been overturned, again, based on the former good and substantial reason. We are seeing good success with those appeals before the administrative law judge, because we're looking specifically at statute and what that individual was charged with and convicted of.
So just again, the top line, thank you for that, by the way. For the top line is that the majority of the denials before Bruin were based on good and substantial. That's right?
Correct, mixed in with some of those individuals who were prohibited by
persons.
law. Correct,
Okay.
Chairman.
And then, so to date, 26 appeals have been successful from prior denials of good and substantial to, based on good and substantial, 26 appeals from the.
Of the more than 1,100 cases presented before the administrative law judges, 26 have been overturned, a majority of those based on the former good and substantial reason.
Okay. And for Bruin, so just to be clear again, it has not had any impact whatever on the, your fingerprinting requirements, your NICS check, any of the other qualifications on Section 5306.
That's correct, Mr. Chairman.
Senator Fulton.
Thank you, Mr. Chairman. I just have one last question. When you talked about the prohibitors that are automatically trigger a disqualifier, previously was marijuana arrests, but with the now medicinal purposes and the legalization of the marijuana, is that still a disqualifier on the federal form?
So, based on guidance from our Attorney General, when we look at the issuance of the handgun permit, it's a state-issued permit. So the federal disqualifier would come from the possession of that medical marijuana card. So there are instances where an individual would be federally prohibited from the purchase or possession of a firearm. However, because this is a state-issued permit, it's looked at from a different vantage point.
I understand that, but so say, for example, the 77R, that's a federal form, or is that a state form?
It's a state form, and I just be careful to venture, because every situation is slightly different. So general rule of thumb, and with some of the legislation that's come through in recent years, so the state license being issued, there could be some conflict, and I know confusion on potential on part of the applicant, where you could be issued a handgun permit, but be federally prohibited from possessing a firearm. And there is circumstances where that could occur, where if you have met all of the legal requirements in an application for a handgun permit, and you could be potentially a card holder of medicinal marijuana, you could be approved. But then the position would be on the federal component of it is you're prohibited from possession of the firearm.
Yeah, that's what I was getting at.
Right, and so there could be circumstances where that does take place because of our status within the Maryland State Police as a partial point of contact for the ATF, because we still do NICS checks. We are the avenue to do that on new purchases and transfers.
Correct.
We're obligated to make decisions on a state level and a federal level.
That's what I was getting at, so I appreciate that, sir. I was just wanting to point out that it's still on the 77R.
The question is
the question specifically about the marijuana or the usage of.
There's several things that we are discussing in this conversation when it comes to the conviction disqualifier for a permit. There's specific components within the law on permit that are separate from the 77R handgun or the purchase of a firearm.
Right.
And I mean, we could have further discussion.
Yeah, we
about
can
the
talk on the
nuances
sidebar.
those things. It becomes quite cumbersome.
I appreciate it, Captain. Thank you all.
Hopefully that answers your question.
I just wanted to make sure I was correct, that
There is
everybody
differences.
understood that there is a prohibitor, not by design, but because of Bruin, the way Maryland's is written, and then we had now we're passing or approving a lot more gun permits, but there's still, just because it's legal in Maryland now to possess marijuana, that it could have.
There could be federal implications.
There's federal implications, and if you start getting out on like the water in Annapolis or out in the Chesapeake and you get stopped by the Coast Guard, how does that work for the person that's carrying their firearm because they're being stopped by a federal agency versus a local state or municipal agency.
Yeah,
So
I understand.
I'm not asking you for the,
Yeah,
I'm just throwing it out there as the conundrum of what we're trying to deal with here. So I thank you.
No, that's really good. Actually, I was going to ask some of the same questions because, you know, it's not really analogous to like security clearances or anything else or federal employment where CDS it's still a CDS, right?
Yes.
Like, so you're
Correct.
prohibited. Here, though you may be federally prohibited from having a firearm.
Owning one.
Or, possessing. Yeah.
Possessing.
But the state will still give it to you.
Well, they'll approve you.
Will approve it. So it's a little bit, I mean, it's important to understand that. Understood. One thing is, since we've approved recreational cannabis, we haven't set up obviously it hasn't rolled out yet. What impact will that have? Because we've only really dealt with the medical cannabis card holders, but what is recreational cannabis? How does that affect your?
I don't know if we're in a position to really comment on that just yet.
Understood.
We have the
No, got it.
legislation in front of us. So I would refrain to even
Understood.
provide a comment on that at this point, if you don't, if that's okay.
No,
No.
I understand, Ken. Thank you.
No, I understand. Senator West.
Thank you. This is a very interesting conversation. So you're saying that if a person has medical marijuana and has a gun permit here in Maryland, a carry permit, and is carrying the gun, and is stopped on a state highway by a state policeman, no consequences. But if he's traveling down the Baltimore-Washington Parkway in the federal portion of that and is stopped by a federal patrol officer, there could be consequences, right?
I'm really at a position where it's tough to provide responses to hypotheticals. I mean, I know as much as you would like to get a tremendous amount of feedback on a question like that, it's hard to say where.
Well, you can enter the state piece. So if you're traveling on a state road and you're stopped by a state trooper, the fact that you are carrying a gun with a carry permit and you got medical and you use medical marijuana, that will not signify, right? That won't precipitate an arrest from a state trooper on a state highway.
Again, I'm really reluctant to provide an answer to a question of that nature, because the details matter, and unfortunately, not having all the details in front of me, I think I would be doing a disservice to try to answer.
It's obviously an issue at some point we're going to have to grapple with.
Understood. Yeah, absolutely.
But I'm fully aware of where you could have a valid handgun permit as a medicinal marijuana card holder, but ATF's guidance provided to us and to the public in general on an open letter stating that by even possessing the card makes you federally prohibited from possession of a firearm. So there's quite a conundrum in those scenarios, but for me to give feedback on every single one would be tough.
Sounds like it puts law enforcement in a very difficult situation.
And we know you can't answer that, but all right. Additional questions from the committee? I just had one last one. I know we've kind of just wanted in terms of jurisdiction, where are the majority of these applicants? Obviously, there's been a significant surge in applications. Where are they coming from? Do you have a breakdown for county or municipality or region?
Yes.
You can go.
Give us a moment, please. We'd have it broken down by county and jurisdiction of active permits.
So if we look at the information we have access to pull for this, a majority of these applications are coming from Baltimore County, Anne Arundel County. Specifically, Baltimore County is north of 17,000 issued handgun permits. Anne Arundel County is about 12,500. If we look at Baltimore City, just north of 8,000 issued handgun permits. There was also documentation pooled for post-Bruin decision as it relates to where those individuals who reside in Maryland live. Again, Baltimore County was just north of 11,000 issued permits since June 23rd. Baltimore City, about 4,600 issued handgun permits. And then on par with Baltimore City would be counties such as Carroll County, Frederick County, and just below that, St. Mary's County at about 2,500 issued permits.
So it's interesting. So it looks like Baltimore County leads the way post-Bruin, and then Baltimore City is second? Or is Anne Arundel second?
And this is just a cursory.
No, I understand. No, I'm not trying to.
We could absolutely provide a list of all jurisdictions. a lot of it's proportional based on the county of population of the county as well.
Understood.
So, you know.
Just trying to glean a general sense of where the majority of them are coming from. But
it sounds like Washington, Baltimore metro areas,
Area.
you know, the higher populated counties typically have the
higher.
volume of applications. And then this is data that's pulled at a certain point. Obviously, with the volume incoming that we have, it changes every single day.
No, understood. Just wanted to just get a general sense of where the applications are coming from. Okay. Additional questions from the committee? Okay. Thank you all very much. We appreciate you.
Mr. Chairman.
Thanks a lot.
Thank you.
All right, excellent. We'll now move on to the second panel. Dr. Webster from the Gun Center on Violence Solutions.
Good afternoon. Mr. Chairman, thank you for inviting me to speak with you today. I'm Daniel Webster. I'm a professor at the Bloomberg School of Public Health at Johns Hopkins. Been studying gun violence for over 30 years and previously led a center that I'm still part of for over 2 decades. I want to be clear with the information I'm sharing with you today that I'm not here presenting any formal policy or view from Johns Hopkins University. I'm just simply speaking from my own experience working in this field. There's been enormous change in civilian gun carrying laws over the past 40 years. If you go back to the 1980s, the vast majority of states, even the states that now require no permits for concealed carry, used to largely ban such concealed carry by civilians or have very highly restrictive laws. Beginning in the 1990s and early 2000s, we started to see many states go transition to what we call a shall issue regime, which is now sort of what Bruin is pushing us to. So I think learning from that experience of these transitioning from more restrictive to shall issue is very important. Perhaps because there's been so much change, probably there's no kind of gun law that's been studied more with more studies. Unfortunately, a lot of those studies aren't particularly rigorous. But the studies with the most up-to-date data and the most sophisticated statistical methods have found that relaxing civilian gun carrying restrictions has led to more violent crime, not less. A state-level study led by Stanford University economist John Donahue estimated that right-to-carry laws have, on average, increased violent crime by about 13 to 15% over a 10-year period when you average them out across the states adopting these laws. Professor Donahue released a study this past year using city-level crime data and estimated that these laws on average increase violent crimes committed with firearms by 29% and robberies by 32%. This study was important because it identified 2 key mechanisms by which these laws are leading to more gun violence in cities. First and most directly is that immediately following these laws, you get an average of 35% increase in thefts of firearms, many of those thefts being from motor vehicles with guns kept in cars, not locked up, often visible. They also found that these laws were associated with a 13% decrease in police clearance rates for violent crimes. Donahue theorizes that police responding to more criminal armed with stolen guns, as well as more civilians with guns in public places, may reduce their effectiveness in their ability to arrest violent criminals and thereby increase violent crime. This is important because it underscores, the theft part underscores how widespread civilian gun carrying can increase gun violence even if permit holders themselves commit relatively few crimes. Our Center for Gun Violence Solutions published research just last year that I think is highly relevant to questions before us now. We were the first study to really break down the specific provisions within a shall issue regime that were associated with changes in violent crime. The things we were focused on is prohibitors for violent misdemeanors, other prohibitions for somewhat vague references to dangerousness or unsuitable character, as well as some provisions relevant to safety training requirements, particularly live fire. We found that overall that these laws were associated with a 9.5% increase in rates of assaults with guns. But when you broke it down, what really stood out was the places that allowed violent misdemeanants to legally get licenses to carry guns is the places where really the violence was increasing the most. Roughly 13 per 100,000 population per year, more violent crimes with guns committed when violent misdemeanants are allowed. Fortunately, Maryland law prohibits such individuals from possessing firearms altogether, but lawmakers may want to consider extending prohibitions beyond the time someone is subject to a restraining order for domestic violence. Often such individuals have used or threatened their intimate partner or family member with a firearm but not been convicted of a crime. We found in our own research that strong firearm laws disarming persons with restraining orders for domestic violence saves lives. Extending prohibitions for concealed carry permits for 3 to 5 years after restraining orders expire would be prudent public policy, in my opinion, in order to reduce gun violence. We did not find that shall issue laws vary significantly based upon these other provisions. We speculate that laws allowing denial of concealed carry based upon dangerousness and unsuitability were not consistently used in shall issue states. We acknowledge also that distinguishing safety training only by live fire requirement may not really be a meaningful distinction in how rigorous the training is. In Maryland, to obtain a license, you need 16 hours of training, and there is live fire requirements with it. It's important to know that no state, including Maryland, has a proficiency test that really assesses whether someone can make appropriate decisions under stress about when it's lawful and necessary to use a firearm in response to potential threats, and then effectively use that firearm when it's appropriate. In other words, no state truly tests the ability to do what they're receiving a license to do. Virtual reality systems could be developed to create fair and efficient tests of responses to realistic scenarios to identify individuals who, if armed in public places, could pose significant risk to others without enhancing their own or others' safety. Such systems are routinely used by law enforcement agencies, including, I believe, the Maryland State Police. New York and other states have responded to the Bruin decision by placing restrictions on civilian gun carrying in sensitive places based on the presence of very large crowds, alcohol use, children, or in certain government buildings. Unfortunately, I'm not aware of any valid research on the effects of similar firearm restrictions to inform Maryland policy. I will acknowledge that what some will say might be obvious, which fights and other acts of aggression are common in many crowded places, especially if alcohol and drunkenness are common. The presence of firearms in such situations would likely lead to unnecessary deaths, injuries, and lasting trauma. Finally, according to Giffords Law Center, Maryland has no statutes prohibiting the possession of firearms with a proper carry permit in hospitals, places of worship, places where alcohol is served, sports arenas, gambling facilities, or polling places. Such restrictions may be prudent.
Thank you very much, Doctor. Questions from the committee? Senator Sidnor.
Thank you. Good afternoon.
Good afternoon.
Could you just, for context, help kind of put parameters around when you talk about gun violence, what type of gun violence we're talking about?
Sure. What we're able to measure systematically and in a standardized way over time and across the place, we use data from the FBI's Uniform Crime Report System that classifies robberies with guns, assaults with guns, these are non-fatal assaults with guns, and homicides with guns. So those are the kinds of crimes that we're looking at in our analyses.
Gotcha. And the reason I was asking, it just so happened last night I happened to be online, and there was an article that came out in the Trace talking about the RAND, the RAND Corporation. They just recently updated a study that they had done, and some of the conclusions that they had noted in talking about, violence, they said that there is moderate evidence that background checks reduce firearm suicides and firearm homicides, as well as limited evidence that these policies can reduce overall suicide and violent crime rates. There is moderate evidence that stand your ground laws, and I know we don't have that here in Maryland, may increase homicide rates, and limited evidence that the laws increase firearm homicides in particular. The other thing, it says there is moderate evidence that violent crime is reduced by laws prohibiting the purchase or possession of guns by individuals who have a history of involuntary commitment to a psychiatric facility. There is limited evidence these laws may reduce total suicides and firearm suicides. I'm curious, are you able to comment on those?
Well, that's covering a really broad area of research. I think it's a great resource that the RAND has provided. Quite frankly, I don't agree with their own method of assessment on each and every one of these things, so it would be a longer conversation, I think, probably, than sort of what we're talking about today.
Gotcha. Thank you.
But if we want to drill down to anything relevant to concealed carry, happy to cover that.
Senator James.
You turn it on. Thank you, Doctor. I think you were speaking from a study that you've done.
Mm-hmm.
Could you either provide the name of it or a link to it, because I'd actually like to read it?
Sure, yeah. So we did provide a copy of our testimony with the references that include this one. The study was providing the very specific data to was published in the American Journal of Epidemiology, which is, I want to note, is really one of the most rigorous in terms of research methods in the field. And the lead author is my colleague, Dr. Mitch Doucette, and I'm the senior author on that study.
So just to follow up, so if I read your testimony, I'm going to find the title of this article?
Yes.
And then you mentioned a proficiency test or suggested one, and indicated there were no such ones being used in the many states that are now allowing this more permissive acquisition of handguns and other guns. Is there such a proficiency test? Are people working on such a test? And could you give us a link or some more information about such a test?
So thank you for the question. So I want to be very clear here. There are proficiency tests, but they generally are, can you hit a stationary target from a relatively short distance?
No, but Doctor, you were talking about proficiency tests that dealt with your judgment, and that's what I'm asking
in terms
about.
of actual, what will you actually do under realistic scenarios if you're carrying a gun around? So my colleague, Cassandra Crofasi, is working with people at the Applied Physics Labs at Hopkins to develop one. But quite honestly, there's very similar things now used in law enforcement. So I think, I don't think we can, such a test could be produced instantaneously, but I actually would strongly encourage the legislature to promote some sort of task force or something to sort of push or advance this, because I think it's very promising and actually fair, efficient, and you know, we now have live fire requirements, and a lot of people in Baltimore City, for example, would probably find it very hard to find a place nearby where they could actually do those live fire. But a virtual reality kind of setup you could do much easier in a lot of different places, and I would argue lead to an actual more real test rather than, again, whether you can at a stationary, you know, under no stress hit a target from,
Okay, just one
you know.
moment. So could you share with the committee the tests already used by law enforcement or direct? I'm new to this subject, so I don't know where to look
I'll
for that
send some.
information.
I'll send some links. Absolutely. Thank you.
And
I think Maryland State Police probably could. Too. Yeah. Yeah.
And just so I can understand, you and your colleagues are working through making additional
Yeah, we're
suggestions.
trying to do
Can
one
I
that's
finish the
more
question? Just
that's
finish
more
the-
civilian oriented, right, than the law enforcement. But honestly, it's a very similar idea, which is you're going to encounter situations, some of which are very obvious threats that maybe warrant, you know, lethal force, but a whole lot of other situations are going to be kind of ambiguous, right? And making the right judgment of when and how to use your firearm is literally a life and death kind of decision.
My question, just let me finish my
Sure,
question.
sorry.
Because I want you to hear it so you can answer it. Are you and your colleagues working on giving us more advice or actually maybe helping develop with yourselves or with collaboration some proficiency tests or standards by which we could consider such a thing?
Thank you. We're in the early stages of testing the virtual reality system. Our plans were sort of slowed by COVID and some other things, but we hope to ramp that up.
Thank you. Thank you.
Thank you, Mr. Chair. I think you mentioned during your testimony the right to stand, which Maryland does not have. Other states have the right to stand laws. I'm informed that in Maryland, people who are learning to use firearms are trained that the best thing to do, in fact, there's some sort of a duty to retreat. If at all possible, you should go backwards and only use your firearm as a last resort. Is that the law of Maryland, as you understand it?
Yes, that is the law in Maryland, and the training certainly covers that important piece of information.
Good. Thank you.
Thanks. The virtual reality idea is actually, I think, a very good one, and not necessarily like it's something that I think everyone could probably maybe get on board. I won't speak for anyone else on the other side of this, but I mean, for instance, in Baltimore, in the city, they always complain that there's no live firing range, and so something like this could bring both sides together in terms of enhancing the training experience, but also accessibility.
Yeah.
So it's not necessarily an adversarial idea, is all I'm saying.
Right. Yes.
And law enforcement uses virtual reality to train all the time, so it's
Yes.
definitely an effective tool. I did have a question for the report Professor Donahue, you talked about. This is interesting to me because you said that when the right to carry laws are on average are increased violent crime committed by firearms by 29%, and robberies with firearms by 32%. And initially, I'm glad you followed up and clarified a little bit. Initially, I thought that was interesting because these are folks that have gone through a background check and training, and that, at least they've adhered to the law in this sphere of their life. So, can you just elaborate more on what the report says? And you've dropped the link in here, so I have the footnote,
Sure.
And I'll read it. But just if you could just talk a little bit more about why that's the case in terms of the theft and other measures by which these guns are getting into violent
thank
elements.
you. So researchers we're at the mercy of what available data we have, of course. So we would love to know all the particular mechanisms. And, a very important question is, well, how many crimes are committed by individuals who have these permits? Quite honestly, there's hardly any data to answer that. I'm going to make a couple of comments. One is, we should recognize that our general set of what we refer to as prohibiting conditions, things that disqualify you from being able to have a gun, we generally talk about, okay, well, here's a safe group, law-abiding group, and everybody else who's had one of these is not safe. I wish that was entirely true. The fact that you don't have a prohibiting condition doesn't mean you haven't done violent or criminal things. You just haven't gotten one of those prohibitors. And in a large group of generally low-risk people, there's always going to be subsets who aren't so low risk. And so their ready access to a firearm could drive a lot for this much broader group. And again, it was important that because, again, there's always been this conundrum of why do we see violent crime going up, but the people generally are safe here getting permits. And the mechanism, that's relevant from this study is gun theft is probably the biggest clear mechanism. And so, again, I think that there are laws to help mitigate that issue to to encourage safe storage of firearms so they're not easily stolen from motor vehicles.
Your answer to the chairman confused me just a little bit, because what I heard you say, and I may have misunderstood because you said several things, I thought you were saying that when these crimes go up, when you have more permitting, was not so much that those that have the permit are committing the crime, but the fact that more guns in the community means that more people probably don't have a permit are trying to steal the gun or rob. So in other words, the permit holders are not the drivers of the crime, but the fact that there are more guns in this community drives people to try to steal them one way or the other. Is that what you said?
That's I think most accurate way to think about what has transpired thus far. And again, there are examples, of course, when people with permits do violent acts, but they're not common. So I think really the driver is making more guns available in public places creates a lot of challenges.
Thank you for coming out today, Doctor. So in one regard, I hear you saying that the idea of putting or approving more permits and having them more accessible for people to steal them is concerning because there'd be more guns available to steal. But on the other side of it, I'm reading in your study that you talk about it doesn't seem that there's no research evidence that mandatory minimums or long sentences for illegal gun possession reduce homicides and shootings. I'm just curious how those two can coexist in your opinion of this.
Mm-hmm. So you fast forward to my other what we're going to talk about in the Baltimore conversation, but I'll definitely touch upon that. So what the broader criminological research shows is there's not good evidence that simply making stronger, more harsh sentences leads to less of violent crime, particularly with guns.
Well, on that point, though, I want to point out that what you're saying is that there's no evidence of that. But we've had a significant spike in shootings in certain areas of the state. Mm-hmm. And at the same time, we've had reform bills put out that are reducing sentences, required sentences of certain and these people are getting out a lot faster that are committing crimes while in possession of illegal firearms, and they're getting back out or getting light to no sentence, and one of which killed a police officer in Wicomico County last year. He should have been in jail. And this is so. I'm curious how you're saying these same two statements in one piece and how they don't coexist together, or how they coexist in your mind, because in mine, I'm looking at it as I'm like, well, there has to be some type of punitive measures in place early on. And like you're saying, I did read the part where you're talking about early intervention, getting into these communities of that are having these struggles, and mm-hmm. and I agree with all that. I think that's outstanding. That community involvement is paramount. But again, as recently as the legislation that was passed and now enacting, these criminal entities are now recruiting kids that are 12 and under. And why are they recruiting kids that are 12 and under? Because there's no criminal penalty for them that carry a gun now. That should be concerning for anybody.
Yeah, obviously that is a concern. I can only tell you what the research has shown and give you my best explanation of how I understand it. I want to be very clear that what the criminologic evidence does say is that certainty of consequences and punishment does matter in terms of probability of crime and deterrence. So there clearly is a deterrence for the certainty of penalty. But when you get to a certain point, adding more on doesn't seem to give more benefit. So we have a longer report on some of these issues that I'm happy to share with you, but you know, our feeling is that, yeah, carrying a legal gun around, concealed gun around, is a dangerous, serious thing, should be thought of as such,
Right.
and we should take it seriously. I don't think that simply adding on more years to sentences based upon available data is the way to do that. I think it's better to get better investigations so that they aren't dropped, even though people are committing the crimes, better prosecution, and better follow-up with behavioral social interventions to reduce repeat offending. So that I'm again giving you my best assessment based upon available data, recognizing that, yes, illegal gun possession is a serious matter that we should treat seriously.
But your data is missing, and I hear what you're saying. You're talking about law enforcement, state's attorney, mental health, but your data is missing the part that's very critical to this, and that's individual responsibility and accountability for their actions. So I think we as a society need to kind of re-embrace that idea that people are responsible for their actions and there are consequences for those actions. And that data isn't anywhere in here. So
you're stating, look, you're stating a particular philosophy. I'm not going to argue on that philosophy. I really aren't. I'm not. I'm
just asking you the idea that I see that there's, you by your own statement, we could do better law enforcement investigations.
Yes.
We could do better state's attorney's office, prosecution. We could do better with mental health stuff. All I'm asking is there somewhere along the line that we do a better job of raising our kids and holding them accountable for their actions?
All right.
Of course. Yeah.
I'm just gonna,
I have a whole course on that, and I teach
Doctor.
in School of Public Health.
Thanks,
Absolutely.
Doctor. I'm going to just interject you. I know we started off with the nexus between more licenses and more guns, and, you know, I get that. So now we're veering a little bit into the next briefing, so I want to just make sure we're keeping on track. Senator Folden.
I'm good.
Okay.
Thank you, sir.
Thank you. All right. Additional questions from the committee? All right. Doctor, thank you. We'll see you a little bit later. I know we delved into the second part of your presentation a little early, but looking forward to it. Thank you very much. All right. Next, we'll have Mr. Pennock from Maryland shall issue. Welcome.
Thank you, Mr. Chair, members of the committee. It's a pleasure to be here. I applaud the committee for conducting this briefing session. I think this is a very useful exercise. I also want to express my, frankly, gratitude to the Maryland State Police. They have really stood up in the aftermath of the decision in Bruin and exercised their duty in accordance with law. So they deserve truly congratulations on how well they have handled that influx of new applications. They have done an extraordinarily good job on a very difficult subject matter. But let's turn to Bruin. So one thing should be clear beyond reasonable dispute, that Bruin affirms a general right to carry firearms in public by law-abiding citizens. They say it repeatedly. There's no mistake of it. It's a general right to go armed. Now, the Bruin does hold that the states may condition that right by requiring carry permits. See the text associated with footnote 9 of the opinion. So we don't have a problem with that. What Bruin does also make clear that carry permits may not be limited so as that would impede the general right. In New York, argued in that decision, in that case, that it's a good proper cause requirement, which was that issue in that case, acted as really a sensitive area requirement, so as to limit people from carrying in places where people publicly congregate. That was the term used. And the court rather decisively rejected that, in saying that defines the area of sensitive locations far too broadly. That's a quote. So what the court did identify was 5 sensitive places, and it's right in the opinion, that a state or municipality or the government may ban firearms. And they're quite specific. They are in schools, in government buildings, not public buildings, government buildings, polling places, legislative assemblies, and courthouses. Now, the common denominator for all those 5 is that they're small, discrete areas which can feasibly be secured by security measures and the like. I mean, you see it already in all courthouses are screened. Most schools have school resource officers, or otherwise it takes security measures. Polling stations are quite distinct. And anything beyond those 5 has to be justified by the government, not by the plaintiff, but by the government, by reference to an historical, a well-established representative historical analog dating back to 1791. Because the scope of the Second Amendment is construed by reference to when it was adopted, which was when the Bill of Rights were adopted in 1791. That's your legal analytical approach, and that's controlling. So what's happened since that time, Bruin was decided, is that 2 states, New Jersey and New York, have passed a much broader sensitive places legislation, and almost without exception, those have been struck down. Now, those cases are ongoing, so there's still not a final judgment on them. So most recently, the New Jersey case, a case called Coons, and I invite you to look at these cases. They are actually cited in the written memorandum I furnished to the committee that you all should have. I think county committee counsel has distributed it to everybody. So that's all available to you, and I invite questions on any of them. And this litigation is also going on, in the spirit of full disclosure, in the Montgomery County litigation, which is currently undergoing in federal district court in Greenbelt. If you'll forgive me, I need water. And Montgomery County has banned pretty much carry anywhere with a permit by specifying that within 100 yards of a long list of locations, including schools, private libraries, whatever those are, basically it makes it impossible to move about in the county. That, of course, destroys the general right to carry that Bruin reaffirmed. But I picked up on a discussion about thefts, and that's a theft problem immensely, because if you have a large number of places where guns are banned, people with carry permits are going to leave them in their cars to go inside those places. Nobody wants that, because one, it deprives the person of the firearm for the purposes for which it was acquired and the permit was acquired, which is the right of self-defense. It also makes the gun unattended in the vehicle. No matter how you lock it up, people can steal it. So you should minimize places of public sensitive areas if you want to prevent those kind of thefts. Now, going beyond these 5 areas that Bruin articulated, this case called Coons versus Reynolds, which came out of New Jersey, quite clearly held that those 5 should be strictly construed, narrowly construed, because broadly construing those 5 basically creates exception provisions that go beyond what Bruin held. So you're not going to be able to say schools means any trade school, which is what Montgomery County has, or colleges or universities where adults are taught and the like. So the analysis is important. I would also draw your attention to what government buildings. Nobody wants to bring firearms into government buildings. But the court chose government buildings by reference to governmental functions. And the analysis set out in the briefs that I sent you, so it should be closely attended to. In federal law, 18 U.S.C. Section 930, federal law bans possession of firearms in a federal facility, but federal facility is defined by the presence of a regular presence of federal employees. And even then, that federal law provides that no one may be convicted of violating that statute unless that federal facility is posted with a no guns allowed sign. And further provides that the bringing in the firearms into that federal facility must be done knowingly. In other words, you knew it was banned and you did it anyhow. That's what knowingly means in the federal law. So our point on this is that everybody agrees, and you heard it again today, that users of firearm, people who are permits, in Maryland that's quite rigorous, and I'm an instructor for the course, so I can attest to that. People get instruction on when they may use a firearm. Now, I've had enormously good instruction from the DEA Academy in Quantico, Virginia, and the FBI Academy in Quantico, Virginia, and by some outstanding instructors. And you can get extremely elaborate scenarios playing out in real time with technology. But every instructor that I know, and I can't speak for all of them, teach that the resort to firearms is a matter of last resort. Resort to even the threat of the use of deadly force is a last resort. Because in Maryland, use of a firearm just simply to threaten, this is a first-degree assault violation. That's punishable by up to 25 years in prison. In other words, if I pull it out and point it at you and I don't shoot you, that's still a 25-year felony. In Maryland, even without a firearm, it's a disqualifying offense to violate the second-degree assault, which can be simply a punch in the nose. And that's punishable by up to 5 years. And that's a disqualifier in Maryland, a permanent lifetime disqualifier. So Maryland has roughly 2,000 statutes on the books which are punishable by more than 2 years of incarceration. And that's the federal and state standard for disqualification. 2,000. And that's not my testimony. That was the testimony of the members of the judiciary here a couple of years ago when they were talking about how many statutes were involved. So it is easy to become disqualified in this state. And yes, the state police inquire into that very rigorously. And to their credit, they're doing it so within 90 days allowed by statutes. This Maryland statute that allows them 90 days to issue a permit. So what we have in Maryland is a very rigorous permit statute, which has the toughest training requirements in the country, has live fire requirements, and not just one live round, which is what the HQL requires, 25 rounds, Mr. Chairman. And it's at distances of 3, 5, 7, 10, and 15 yards on a V-52 target, which is a silhouette target. You also have people who have previously gotten permits for what was then required as a good and substantial reason. And these people include people who are under active threat, who are needs of armed self-protection because they are actually threatened, and they've been able to demonstrate that. This includes people who are using their firearms as carry permit holders to protect their synagogues and their churches from armed attack, who are licensed to do so for that specific reason by the Maryland State Police. There is a Maryland State Police prior to Bruin had a issue of presumed risk categories. That includes prosecutors, judges, and by implications, member of this body, who are at risk on a presumed basis to violent harm. And those people were getting permits. Now, they still had to do all the other requirements, but they were all getting permits. Any legislation that this body enacts will affect not only the general public, but all those other people who already got permits for very good reasons and were recognized by the state police as good reasons. So that's very much an issue right now in Montgomery County, where I have submitted, and I'm counsel for the plaintiffs in that case, in full disclosure, submitted declarant after declarant that has tests that they are protecting their synagogues from the threat of attack. And that Montgomery County ordinance that issued in that case has banned it, leaving those places of worship unprotected. And that's a travesty. So we'll like it or not, the reality is that there are violent criminals in this world who will do you harm. Could we always improve the training? You bet. I train people to do so at the last resort, but once in a while, and you see instances after this, where people have had to resort to force, and it's fully justified. Supreme Court has now articulated that's a constitutional right. So that is off the table, as Heller said. So when you legislate and consider bills on this subject, you must remember within that framework is a very narrow framework in which legislation can be enacted. If you want to make sensitive areas of those 5 that are articulated by the court, Bruin allows it. Whether it's a good idea is a separate question, but Bruin allows those 5. But once you get beyond that 5, then you're going to have to find an historical analog. And I've done the work. There's no historical analog, for example, bans on possession of churches. In fact, back in the colonies days, laws were in existence that required people to bring their firearms to church. Believe it or not, it's true. The same thing is for a whole host of other areas in public. You also have the Supreme Court's ruling that you can't simply ban firearms in places of public assembly where people happen to congregate, because there's no historical analog for that. That's the test, and it's the government's burden in each one of those. So I'm happy to accept questions. I think that summarizes what I want to stress today. I believe in the right of self-defense. I believe, and I teach the course because I believe in it.
Chairman, and thank you for coming in and giving your time to inform us. I've heard it said twice that as we have the level of legal gun purchases and applications being put in, and more persons are obtaining firearms legally, that there is a correlation between gun violence as a result of persons stealing guns from cars, etc., who have legally obtained them. So, on the other hand, our communities are infiltrated with illegal guns coming in from everywhere. Maybe you're not the person to answer this, but someone can. Does there seem to be more crime that's rising as a result of persons stealing legal guns as opposed to the ways by which illegal guns are coming into our communities, so that we would want to spend more time, maybe, and I don't have a position yet one way or the other, but more time maybe focusing our legislation and policy and funding on the illegal guns that are coming in, as opposed to trying to bring down the number of legal applicants who receive firearms.
So I want to be careful here. The question, one of the answers to your question is that permit holders don't commit crimes. I think you've heard that today. And they don't. I mean, there's a study attached to my testimony where that's documented. So in terms of the decrease of use of violence that's correlated is simply as a correlation, not a cause and effect relationship. So whenever you hear the word associated in the studies or read it, you should say, wait a minute, that's not a statement of cause and effect, that's an association, which could be simply a a statistical association. And I'll give you the perfect example of the logical fallacy associated with correlation. Sickness is statistically correlated with hospitals, but that doesn't mean hospitals cause sickness. So when you read correlated or associated, you have to be very careful that you're not actually implying a cause and effect relationship. So is there a problem with gun theft? You bet. And this state doesn't punish gun theft very severely. If it's under a certain amount of money, I think it's like $900, it's punishable as a misdemeanor, as a minor misdemeanor under the sentencing guidelines in this state, probation for the first offense, probation for the second offense. So it doesn't matter where the guns are coming from. Gun trafficking is always going to be a problem, and there's really not much you can do about it. If they're willing to violate federal law and commit federal felonies by trafficking firearms into this state, there's not a lot of states going to be able to do so to prosecute them.
And I only brought it up because it seemed that they had, as though they had new information on the rise of gun violence related to guns stolen illegally from persons as opposed to guns coming into this country and into our communities that may not have been legally owned at all. And so is there correlation between those the 80,000 that applied for guns and those and received them, or firearms, and they were stolen right here and used, as opposed to the methods by which guns are entering into our communities from many, many other places. All of them there are legal, but I just want to know if they kept those.
The short end is that there's no direct correlation between those two. Certainly, to the extent that there's an influx of guns, that means more guns are available to steal, so yes, there's a correlation. But there's plenty of guns to buy in Maryland legally, and there's plenty of guns to steal in Maryland illegally, and those thefts are going to take place regardless of where they're coming from.
Thank you. And I have no position, it's just that I thought I heard him saying one's rising more than others. But okay, thank you, and thank you, Mr. Chair.
So
thank you for that, and I got it now.
So nobody wants to have their firearms stolen, and to the extent that the state can do anything to discourage firearm theft, we're all in favor of it. We testified in favor of that last year, and the year before that, and the year before that. But what you cannot do, and the Supreme Court is quite clear on this, is alleviate the secondary adverse effects of gun violence and crime and generally by banning the right itself, the exercise of the right. You can only alleviate by focusing on those secondary effects and not. So, for example, you can't say, well, we don't like gun theft, so we're going to ban all guns. That's not going to work. And you can't say we're not going to have carry permits because we don't want guns out in the street. That's not going to work. So there has to be a strategy to addressing the particular problem that you're talking about without necessarily infringing upon the right itself. That's what Supreme Court precedent holds, and that's what we're litigating. Any other questions?
Additional questions from the committee? I had just a couple real quick ones. One was, since we've been talking about the theft of the firearm, is it illegal to have your handgun or your firearm in a car or somewhere that's not readily accessible? But let's say you had, I'm thinking about theft, right? So if I went into the grocery store, I had it in my glove compartment, or I had it in my back seat, is that illegal?
Assuming that you have a carry permit?
Yeah.
On that assumption, no.
Yeah.
But of course, if the grocery store says no guns allowed and you need to buy groceries, where else are you going to put it?
Yeah.
So that's the problem. So the idea that you create more sensitive places makes that problem even bigger.
Okay. So the answer is no, it's not illegal to keep it.
It's not illegal.
The second thing is, so then your general opinion on, so obviously we already have through either regulation or code a list of prohibited places that already exist in Maryland, either through regulation or code.
Most of it's in regulations.
Yeah. What impact do you think Bruin will have, or do you foresee challenges to those locations? What impact do you think this case is?
I do, and I intend to bring them. So we have, for example, regulations that ban the possession of firearms in state forests, hundreds of thousands of acres of woods. That's not going to fly after Bruin because there's simply no historical analog that could possibly justify it. We have regulations that ban state parks. Same result. So right now there is no ban on possession of firearms in state places of worship, which is why the state police issued permits to people, members of the congregation, designed to defend those places of worship against attack. So yes, there's actually a list on MSI's website that has a long list of these administrative regulations, and which are places where, because on the back of every permit, there's a limitation placed there by the Maryland State Police pursuant to Section 5-307 of the Public Safety Article. And that back of that permit says, not valid where firearms are prohibited by law. That's a quote. So any place where they're not valid by state law, by local law, by regulation, or your permit itself is not valid. Now, if you carry where your permit is not valid, that's the same thing as not having a permit at all, which opens you up to charges under 4-203 of the criminal law article, which is punishable by up to 3 years in prison, which is a lifetime disqualifier.
So that question leads me to the last question is, so after Bruin, means test, balancing test out.
Correct.
Historical analog in, based on 1791, adoption of the Bill of Rights.
Correct.
Understood. So the question, the confusing part for I think all of us is, what is analogous enough?
So that's a very good question, Mr. Chairman. What the Supreme Court said, outliers don't matter. Laws in the territories don't matter. Laws that post-date the Civil War era, after 1865, are less persuasive, or may be read if it's confirmatory of earlier laws. But in what the court articulated was two metrics, the how and the why. And the how and the why was central to the focus on the right of self-defense. In other words, if there was a game law that prohibited possession of a firearm while hunting on somebody else's land, that's not analogous under the Supreme Court's ruling because it wasn't intended to affect the right of self-defense. It was intended to stop poaching. And poaching, and several of these cases have already addressed that post-Bruin, is non-analogous. So it has to be analogous and comparable, quote unquote, to what the restriction was on the right of self-defense at the time. So the court articulated 5, which were analogous, and said that those can be now imposed. So you have a list of 5, and you can go beyond that, but you're going to have the same kind of inquiry on whether there's a comparable restriction in 1791 as to on the right of self-defense. You can't carry in here, legislative assembly, and that's analogous, and we're fine with that, or any of the other 5. But I would stress again that they can't be expansively defined, otherwise you're undermining the very general right to carry that Bruin expressly held exists.
Well, I suspect that analysis is going to be the subject of significant debate in the years ahead.
I'm certain.
And that's going to be the lead-in to Mr. Levy, who's next. And so, if there are any further questions from the committee, we'll pass the baton. We'll have our next presenter. But thank you very much for your presentation and for your 80-page document, single-spaced. We appreciate it. Thank you very much.
Well, in defense, my pages were only 8. It's the attachment were long.
This is 80 pages. This is good. It's good. It's good.
That's data. You might find it useful, Mr. Chairman.
It's substantial. All right, Mr. Levy from Everytown for Gun Safety. Welcome. Good to see you, and thank you for being here.
Thank you, Mr. Chairman, Mr. Vice Chair. My name is Samuel Levy. I'm the Regional Legal Director at Everytown for Gun Safety. We are America's largest gun violence prevention organization. I have the great privilege of working primarily on our state legislative efforts in the Northeast and Midwest, including here in the great state of Maryland. It's good to see many of you again, some of you for the first time. And I will say no trees were harmed in the preparation of this testimony. You just get me. So it's my pleasure to be here. Thank you for having me. I want to talk a little bit about the holding broadly, what Bruin means, what it stands for. You've heard a lot about it already from counsel and from Mark and others, but just to be clear, it stands essentially for 2 propositions. One is very specific and one is very abstract. The first very specific question is whether states can require a showing of proper cause from applicants who wish to carry concealed guns in public and obtain a state license to do so. The answer to that plainly is no. The court considered that ruling in New York, that longstanding regulation, and said it violates the Second Amendment. So, as you heard, there are 6 other states who have essentially identical or comparable, substantially identical requirements, including Maryland, New Jersey, Connecticut, California, Hawaii, and Massachusetts. who now, like yourselves, have to deal with what it means to remove that section from your code and what it means for the rest of your permitting process and ensuring public safety. I'll come back to all of that in a moment. Then there's everything else. Frankly, the more impactful aspect of the ruling may be that it announced an entirely new framework that the courts are going to use to decide Second Amendment challenges going forward. So that means all of the case law that was decided between Heller and now, using, as you've heard, the sort of prior means-ends analysis, was tossed in favor of the text, history, and tradition framework. We are 6 months removed from that ruling. I dare say we are 5 or 6 years away from understanding exactly what those analyses are going to look like, what the circuits are going to do with that, where the splits may emerge, and ultimately what, if anything, the Supreme Court will say about it. So if anybody comes before you and says they understand exactly what's allowed and what's not in any other context under this decision, I submit they're selling something. So I'm happy to discuss some of that because it's important and it's germane to other bills you're going to consider this year, and if you're interested, I'm happy to talk about what that looks like. In our view, it's a wrongfully decided case. Obviously, it is the law of the land now. It does leave a great deal open to interpretation, as you mentioned, Mr. Chair. And so we can talk about the contour of that, but it's worth noting at the outset that with respect to concealed carry and permitting processes, as Mark acknowledged and everyone else does, it does nothing to undermine the practice of states issuing concealed carry permits. It does nothing to undermine training requirements, background checks. It stands for the proposition that states that do what Maryland does, which is investigate not just paper disqualifiers, convictions, et cetera, but also assesses whether a person is dangerous. That can be factored in as well in denying permits to people who are in fact determined to pose that kind of risk to public safety. All of those things withstood the decision. They continue to be the law in states that apply them, including here. But the question now really becomes, as you've heard, I mean, by my count from the state police's early returns, you're talking about a 500 or 600% increase in applications. And the upshot's going to be simply more guns in more public places, right? And the risks that presents is not, as you heard, necessarily permittees committing crimes, but what is the presence of those guns in locations that serve alcohol, in locations like this where you're deliberating sensitive issues, courthouses, et cetera? What are the risks in that universe? What are the risks of stolen guns, right? What are the risks of guns that then get stolen and flow into the illegal marketplace? And then thinking about the who, right? Who can obtain these permits? Obviously, proper cause is out, but the state still has ample levels that it can pull to ensure that the people who are obtaining these permits and carrying in public are qualified, are legally, of course, allowed to possess that weapon. And I'll talk a little bit more about that as well. So as you heard, there are 2 states have already taken steps to respond to the decision. New York just in the days after the decision back in June. And then New Jersey just a few weeks ago. I will correct Mr. Pennock, who said that those laws have been struck down. That's not true. As you can imagine, there were plaintiffs lined up ready to challenge these laws the minute they were passed. Those cases were brought in districts that, of course, are favorable to the defenders of the Second Amendment right. And those decisions, while they did issue temporary restraining orders or preliminary injunctions, have all been stayed. Those laws are all still on the books. The Second Circuit is currently considering an appeal on the New York law, and New Jersey's decision was just handed down a few days ago, and we expect that to be appealed to the Third Circuit shortly. So those laws remain in effect, and again, they are both efforts of the kind that I'm going to ask you all to consider, which is what can you do to make your permitting system as strong as it can be, as clear and transparent, so that it's effective and fairly enforced, maximally protective of public safety, and also ensures that it withstands subsequent challenges for generations under this new kind of scrutiny. So, so you think about basically, as I said, those 2 buckets. There's the who and the where, right? The who question is who can obtain these permits and who cannot. Obviously, Maryland already has a set of categorical disqualifiers of who can obtain, just as you do for HQLs. But it's worth considering if there are any other kinds of convictions that do indicate dangerous that are worth considering in that, right? Some states have thought about multiple DWIs, for example, or certain types of, non-domestic violence, violent behavior, violent misdemeanors. You heard about the efficacy of some of those prohibitions from Dr. Webster. That's something that bears, addressing and considering as you think about the ways to strengthen the system. And again, the other really vital piece here is not just folks who are paper disqualified, right? You heard about the great work the state police are doing to process these applications, do their background checks, complete an investigation. That's not just paper disqualifiers, right? That's understanding if a person has had law enforcement at their home 4 or 5 times for domestics that didn't lead to arrests, right? Or didn't lead to convictions because cases didn't proceed for whatever reason. Those are indicia of dangerousness, right? Those are things that should and can properly be brought to bear when a licensing official, in this case the state police, are deciding if a person should be issued a wear and carry. Making sure that job is done well is really important, obviously, with the crush of applications that are coming and the rise of interest in light of the change post-Bruin. Again, I don't handle the budget, but again, vitally important that state police is resourced to do that work, that there's clear guidance on how it's getting done. And I think what's really important for not just the impact and the efficacy of the law is that those standards be clearly announced, right? It's not a question of abstract. It's really a question of these are the very specific factors that the state police are going to consider. I think it's a good idea as a matter of policy to have all of those decisions issued in writing. I didn't ask the state police that, but I don't believe that's a current requirement. I think making sure that applicants know the basis on which they're denied in cases where they are is vitally important. And I will say Maryland's law is among the strongest in the country in terms of appeals. That's another important process to make sure that folks who are denied have an opportunity to be heard by separate arbiters and plead their case in cases where they feel they've been wrongfully denied a permit. And then I think you come to the question of training. You heard a lot about that from Dr. Webster. Maryland does require training, but again, part of the concern here is not just handling and safely using the firearm, but also the things that I think we all agree on, which is de-escalation. What do these encounters look like? Are firearms the first or second or the last resort? I don't think there's much disagreement on that. But those kind of skills that, again, don't necessarily aren't tied to live fire per se, but are very much situational. These are situations where you're going to have more guns in public. You're going to have people getting into disputes, parking spots, the game, whatever it might be, making sure that people understand what it means, what the law of the state is when it comes to the use of deadly force to defend oneself or others, and all of those things should be considered as well as part of a robust training regimen. You heard about storage again. This is vitally important, right? Because the issue is not just the guns in public, it's when those guns are not stored securely and they are accessible. Again, I hate to disagree with Mark, but the only choices aren't going to the grocery store with your gun or leaving it on the front seat of the car, right? There's tons of storage devices that are secure, that are biometric, that are locked with a key, that are not visible from the outside of the vehicle, that don't indicate in a way that, hey, there's a handgun I'm going to smash the window and take it. So I think a thoughtful conversation about what secure storage looks like outside the home in a world where there is more public carry is vitally important in this context as well. And then finally, I think on the question of where. Sensitive places are a thing that are defended by the Heller decision before Bruin. They were reiterated in Bruin by naming the specific locations that have previously been approved in that decision. But as with everything, these are non-exhaustive, right? I think any characterization that those are the 5 places you get to prohibit, again, doesn't comport with the court's decision. The next step is going to be the analysis and analogy of what places are like those places or pose the similar kind of risks and concerns to support some manner of prohibition. And I think even in a world of text history and tradition, once you get past the plain text of the amendment to see if it's germane, you're going to have that same conversation. And so I think there are ample resources I'm happy to share with any of you in terms of the historical record for where these restrictions took place, which places make the most sense of them and are maximally defensible, which places are likely to draw challenges. Those are things that have to be kept in mind as you prepare to legislate and strengthen the system. So as I said, I think the overall goal is to make Maryland's concealed wear and carry permit law maximally protective for public safety, maximally transparent and clear for everyone who wishes to carry outside their home and have a permit here in the state. And then I think happy to take some questions, but the nice thing about batting cleanup is I can take a couple from folks that already had them if I can be of help. Senator West, you asked a question about open carry. The state doesn't differentiate between open and concealed for handguns. Whether you wear that gun on your hip or concealed on your person, you have to have a wear and carry to do that. There is no such permit requirement for rifles and shotguns. So if you do carry one of those in an open fashion, the law is silent on that currently. There was a question about, I think from Senator Folden, about reciprocity and people coming from other states, Utah. Yeah, Maryland has no reciprocity. So you can't come from another state with a permit and say I'm good, as some states do. So if you do want to carry, you can pass through for other reasons if it's secured, all that. But if you're here vacationing or whatever it might be, if you want to carry on your person, you have to have a Maryland wear and carry. And then finally, the question from Senator Muse about trafficking, right? That's a real problem, right? The wear and carry system and guns in public, as pertains to Bruin, is one very specific part of the gun violence problem in Maryland, right? There's firearm suicide. You're all going to talk for several more hours about everyday gun violence in cities like Baltimore that is driven in large part by illegal guns, by traffic guns. And while gun thefts here may be a part of that story, there is a ton that can be done to address gun trafficking, to address the ready supply of guns coming in from out of state. The vice chairman has a bill regarding how the firearm industry conducts itself with respect to sales across the country that end up here in Baltimore, for the things they could be doing better to ensure that guns aren't being given to straw purchasers, to traffickers. So again, I think characterizations that there's nothing we can do about that, there's always going to be trafficking, simply aren't true. So I think there's lots to be done on that front with respect, and in addition to a whole host of others, of all the things that you need to bring together to address not just the wear and carry problem and how to make your laws as strong as it can be, but the many facets of the gun violence problem here across the state. With that, I'm happy to take questions.
Thanks, Mr. Chairman. We're going to deal with lots of these issues. But let me just ask one that bubbles to the top of my mind, and that is privately owned property.
Sure.
Whether it's store, home, other places where people come. So would it be true that under Bruin that the owner of an establishment would be permitted to ban guns on that premises, particularly if there's signage put up that no guns are permitted on this property?
Yes, I think so. And it's worth noting that one of the features of both New York's and New Jersey's law is separate and apart from all of your enumerated sensitive places, right? Sports stadiums, places, bars, places that serve alcohol. There is a presumption, essentially, that if it is private property, if it's a home or a business, the presumption, again, in a world where there is more public carry, is that you should presume, unless you've been granted permission by the proprietor, the owner of that space, to actually bring your weapon there, then it is, in fact, prohibited unless and until you get that permission. So it is a choice that private property owners can make. The question is whether the presumption should be guns are allowed everywhere, and then you have to say no guns versus no guns are allowed, and we'll tell you if it's okay.
The presumption issue is a more difficult question, I think. You can be out in the woods walking along and carrying, and unbeknownst to you, you could walk across private property, which is not posted or fenced off in any way. And I think it would be unfortunate if the law in Maryland were to be you are presumed to have carried the gun illegally onto that private property, and you can be prosecuted as a result.
Yeah, and I'll say for spaces like that, you get into certain, hunting grounds, public parklands that might abut with other things, or places that have, say, a playground inside as opposed to other spaces. It's really important, I agree, to be clear about where those spaces are, and I think a lot of the work of wherever you all settle when it comes to sensitive places across the state is public education, is making sure people are aware, not just it's illegal to carry is on the back of the permit, but really making sure that folks who have these permits and want to abide by the law understand where those contours are and where those spaces are, because again, we're not trying to fool anyone.
And to bring that question into a more urban setting, if you have a delivery man who's carrying, and he delivers something to my house, it would be odd, I think, to suggest that because he entered my property, that he is now presumed to have violated the law and subject to prosecution, unless there was some kind of a sign in the front of the property, no guns on this property.
Well, again, I think these are details that I'm eager to help you all flesh out once you have the conversations. But, a couple of things to bear in mind. One is, these in New York and elsewhere, they exempt obviously certain classes of carriers, right? Certain law enforcement people who carry for their jobs, armored car drivers, things of that nature. So some of those come aside. If you're talking about the Amazon guy, if he happens to be, a person who has a valid wear and carry, again, those are questions of if he's coming and going and not coming into your home, do you treat that differently? Those are things that are to be.
Well, that all sort of impacts your suggestion that we could pass a law that would say it was presumed that you cannot go on someone's private property carrying a gun unless you know for a fact that the person admits you onto the property. Then in practice, I think that's going to be very difficult to deal with.
Well, yeah, and we can assess that again in terms of, knowledge is generally required for these things, as Mark said, so it's got to be a situation where you're walking into someone's home or a place of business or a restaurant. And again, I was in law enforcement as a prosecutor for a long time. These are always very fact-specific questions, but happy to help suss those out as well to make sure.
Thank you.
Sure.
Thank you, Mr. Chairman. Mr. Levy, I really appreciate you coming out. I think you've been very insightful on things. I just wanted to kind of go back to the one thing you said about, and I appreciate you addressing like the reciprocity, because that was great clarity. I wasn't as articulate as you, but I was trying to get there, so thank you. So I find it interesting that you're speaking about the presumption element of the new the Bruin or whatever the decision that we're trying to deal with here in the state. And I mean, I find it interesting that we're talking about a presumptive measure of law, where we're going to be saying that it would be presumed that you would know basically that you're not allowed to carry it in all these places, or it would be so. Whereas shouldn't it be presumed that if you're issued a permit that you have the knowledge that you're in the state of Maryland, except for the 5 carve-outs, which are very specific, that one could presume that they're legally carrying anywhere within where the permit is issued. And the reason I bring that up is, a very important element. Did you say you were a former prosecutor? Okay, so a very important element of prosecution of a crime is knowing that the defendant that they had the knowledge they were committing a crime. So when we're talking about presumptive measures, if someone is presumed that they're acting legally and carrying as they're afforded that right to, I think that taking the other angle of presumptiveness that they've broken the law by carrying it out that's a really I think that adds to a lot of difficulties for people when there's no willful and wanton act on their part.
Sure, and let me be more precise because I wasn't. When I say presumption, it's literally just with regard to the private property question that was raised, which is that I'm a proprietor of a place that is not separately a sensitive location, right? I don't run say you do bars, for example, as many states do.
Yeah.
If it's some other private location of business, the presumption is why should the owner presume that everyone's just going to walk in and have guns and then it's on them to tell them to leave, right? As opposed to vice versa and making that choice.
Yeah, I mean, I agree with that, and I understand that, and I appreciate that. I mean, I just know that there's a lot of presumptiveness. I would like to think nobody's just going to come onto my property and come into my house,
Sure.
But if I don't paint a blue circle around trees or post it no trespassing,
Right.
then they've done nothing wrong by walking up to my doors and looking in my house. And so there's a lot of things that I have issues with on the presumptive side of things versus as a private citizen or business owner taking your own responsibility to mark things as such or post as such that you don't welcome guns here, and people who want to patronize that facility can determine whether or not they want to go there or not then.
Yeah, look, and it's right now, if you go to the MSP website, they publish a list, it's quite long, of all the places where guns are not allowed, much to their credit. I think any part of this work should be predicated upon a real focus on how it gets implemented and carried out. That includes educating the public and the many, many, many more people who are going to have wear and carries to where they can and can't go, separate and apart from the
Yeah, no, I agree with that, and I appreciate your time. Thank you. Thank you, Mr. Chair.
Thank you, Mr. Chairman. It was earlier referenced that the date of analogy is appropriately 1791 when the first 10 amendments were adopted. Is that the decision of the court? Is that
No, the Supreme Court didn't say specifically. I mean, so the adoption is 1791. Of course, they were applied to the states through the ratification of the 14th Amendment about 50 years later. Based on what you've seen from the courts below, we don't know yet. I mean, both of courts of different jurisdictions across the state have looked at closer to the 14th Amendment date or both, and there's frankly history going back long before that to England. One of the problems, I must say, with the Bruin standard is they don't tell you how to do it, right? There's no precise guidelines. Judges are not historians. The absence of a historical record doesn't mean there was affirmatively nothing there. It could just be the absence of a record. What you're going, the fear is that it's just going to be applied so differently over time, over the next several months and years, that it's going to take time to refine and maybe more opinions from the learned justices as to what exactly they meant, because it is quite broad.
There are, I guess, 43 states. I've just been reading the Bruin case. I've read it before, but not every last sentence, but some of it. Anyway, there are 43 states that don't have any of this. It's, shall. You should have, there's not a permitting scheme, right? Now, this case is right. There are about 25 that, let me just get the language right. You don't have to get any permit for a concealed carry gun at all in about 25 of them. I guess what I'm asking is, in any of those 43 states, is there a scheme for how to deal with this issue that your organization thinks is good, or are there elements from the 43 states that you've looked at that you think we should look at?
Sure. So thank you for the question. It's worth defining a couple of terms. First is, as Dr. Webster mentioned, permitless versus non. What's happened over the last decade or so is that states that did require a concealed carry permit to carry in public, regardless of the standards, did away with those laws. They said if you want to carry in our state and you're a legal possessor, you don't need to bother getting a permit. Some people still might for reciprocity reasons because they want to go from state A to state B. There's benefits to having a permit that are separate from whether you can carry. That's what we mean when we say permitless. The distinction the court made in Bruin was between what they called may and shall issue, and the meaningful difference is in may issue states, those 6 states required this special showing. You had to show not just that you were lawful and then you met all the other standards, training, et cetera. You had to then demonstrate to the licensing official that you had a proper cause, a good cause to carry in public. That was then adjudged by the licensing authority and then determined. That's gone. So, Maryland, in fact, had one of those things, and so you're now going to have to strike that from your code and think about what it means for the process. But the rest of your process is actually really robust. I think you are one of the states that has a really good system, but there are things we can borrow from other states, like the things I mentioned of like, what are your categorical prohibitors for non-felons, things that aren't already prohibiting from possession or getting an HQL. For violent conduct, as I said, things that evince recklessness or carelessness, people who might be behaving in public in ways with guns that are contrary to the benefits of public safety. Then there's making sure that your pre-existing section that actually allows denials to people who are dangerous, not just based on their paper record, but based on an assessment, as you heard from state police, of their prior arrests and other conduct that might indicate, again, that they pose a risk, an unreasonable risk to themselves or others. That language is quite good in the code. I think what you can do to really strengthen it is, and to improve the way it's applied across the state, is set some really clear parameters of what's being adjudged, right? And state police can do that and put those guidelines out so it's clear and understood, and then think about the other aspects of the process, right? Your appeals process is quite strong, but again, you want to be thinking about things like written denials, again, because when there is a challenge if there is a challenge that gets to the Supreme Court or somewhere else, that you want to stay away from things that could be adjudged to look like proper cause, which was held by the court to be too abstract and too discretionary, and things that are a little more concrete.
And just one follow-up. I could ask every witness today because I'm totally confused on the issue. We've got, I guess, concealed and open carry. I've heard Maryland makes no distinction. Obviously, the Supreme Court just keeps talking in this case about concealed carry. And states, some states seem to make a distinction. Can you clarify for me what that difference is, or whether there's any difference, because I do not understand that.
Sure. So purely as a matter of fact, open carry is, the sheriff with the gun on his hip or an officer who you see come to the podium. Like, that's a visible gun. When I walk in the room, I'm carrying a gun. The question is how states address it, right? They pose slightly different dangers, right? A visible gun has its own separate public safety implications, right? Because the research shows that people are more aggressive in the presence of visible guns. Things escalate in ways they might not otherwise. And so states have different approaches in some cases of how they regulate concealed carry that's not plainly visible when you walk into a room versus open. And as in Maryland, a lot of states differentiate between handguns and rifles and shotguns. So in Maryland, you can't do either. You can't carry openly or concealed without first getting a wear and carry. But that's not true for rifles and shotguns.
Okay, thank you.
Excellent. Thank you, Senator James. Additional questions for Mr. Levy? If not, thank you very much. This has been very helpful.
Thank you, Mr. Chairman.
It was a pleasure. All right, with that'll conclude this portion of the briefing. So we have to reset our broadcast system to start for the next one. So we're going to take a 5-minute break, no longer, 5-minute water break, and then we'll come back and we'll talk about trends and efforts to combat gun violence in Baltimore City. First up would be State's Attorney Ivan Bates.